Good morning, guys. Can you see me? Good morning. Can you see me, guys? Okay. Can you see me, guys? Please just give me a heads up so that I know that yes, I'm visible and I'm audible. Just give me a heads up that yes, I'm visible and I'm audible so that I know at least you can hear me and you can see me. Please, any of your friends who wanted to join but because of the glitch were not able to join and they are not aware that the live session has started, please just let them know that the live session has started so that even they can join the sessions. Okay? Now, how are your preparations going on? At least drop a message. Let me know that you can hear me, you can see me, my voice is audible. Am I audible or am I not audible? Is the voice fine? Is the voice fine? Okay, now I think there was some slight disturbance. Now let me know if the voice is okay. Okay, let me know now if the voice is okay. So as I told you, we'll be discussing we'll be trying. So as I already told you that I'll be discussing questions of Indian Contract Act today, and I've already told you how many times, I don't even remember. Writing of answers is important, really important. So today, as you had told me that you wanted me to discuss answers of Indian Contract Act, today we are going to actually write answers from Indian Contract Act, and I thought that this time I will take up. And guys, you will not even wish good morning, huh? You have come online, you are there, and you won't even wish good morning also, huh? So today, as I told you, I'll be discussing Indian Contract Act, and we have already discussed. So I was thinking that what we will do is, I was thinking I'll do this September terms question only, so that you will know the paper pattern, how it was, the type of questions, and you know that fear also will go. So I will, and how we are going to do this is, I'm first going to let you read the question and you will tell me what provision according to you should be there in the answer. And then we will sit and write the first and the last paragraph. That works fine with everyone? That works fine with everyone, guys? Right? So we will first read the question, you will tell me what provision you will write here, and then we will write the first and the last paragraph. Okay? So starting with the first question, and I hope you have a paper and a pen also with you, because I want you to at least write the provision, as in not write it full, but at least what provision you will write, that much you should write. So the first question that I want to take up right now is page number 20. So as I told you, I'm going to ask you questions which were asked this term, okay? So can you see this question? Question number 11. Can you see the question? Question number 11. As I told you, September 24 questions only we will take up. Can you see it? I want you to read the question and tell me what provision do you think would you write for this? Increase the size of the screen so that you can see the question properly. And I want you to drop a message. The moment you're read with the question, you have read the question, you're done with what provisions you have to write, I want you to drop the question provision and then we'll discuss it. Others also should give the answer, guys. Others also should give the answer. Expenses or loss? Loss, Janam, are you sure? Loss. Mr. A was running an orphanage. His friend Mr. S, a philanthropist, agreed to donate 2 lakh for the treatment of a child. This is what? Donation. Correct? So is a promise to give donation actually enforceable? No. A promise to give donation is actually not enforceable. Who was suffering from cancer? On emergency, Mr. A incurred 1.5 lakh on the treatment. A promise to give donation is not enforceable. But if I have incurred some expenses, I can recover. How much can I recover? 2 lakh or 1.5 lakh? 1.5 lakh. A very important message to all of you who are attending the session right now or who will attend later. This session is only for those people who are really serious for their JAM exam. Out of all the number of people attending this session, only one person has answered. What are the rest doing? It doesn't take so much of time to read the question. At least there should be some answer you give. Otherwise, what is the point of this session? Then don't attend the session only, no? You will give wrong answer, that works, but not giving any answer doesn't work. It's a Sunday morning, 9:30 in the morning, you're sitting here, not for the fun of it. You're not sitting here just for fun. So if you're sitting here, that means you really want to do something about it. So don't you think you should be answering rather than just sitting and listening to the class? Next question, I want an answer from everyone. So what is, this was September 24 question. The first question I'm just writing, how will you write the answer? Obviously we have 3 paragraphs, you already know that, right? Please, I repeat again and let me tell you absolutely very, very clearly, there is no such concept that I have to write section numbers, otherwise my marks will be deducted. Absolutely no. I have to write exactly as it is given in law, otherwise my marks will be deducted. Again, absolutely no. There is no such hard and fast rule. Please, you just have to use the technical words and that's enough. So please, when you are studying also, don't stress yourself out. Oh my God, I have to remember this, I have to remember. No, there is no such thing as remembering this and that. So there is no such hard and fast rule that we need to remember the section or the law language. As per the provisions of the Indian Contract Act 1872, a contract to be valid must be supported by consideration. So, if consideration is not present, the contract is void. If anyone wants to write it on their own rather than writing what I am writing along with me, you can also keep writing your answer, put it on mute for the time being, right, and see how much your answer is matching and is it correct. The contract is void. However, there are certain cases where a contract without consideration is valid, right? In case of charities and donations, a promise is not enforceable. However, if on the basis of the promise the other person has incurred any liability, he can recover to the extent of liabilities incurred. If you don't practice writing, just writing one answer and your hands will be like gone. Like I can already feel a pull on in my arms. So that is why writing practice is very, very important. So what is the question? Whether A can claim 1.5 lakh. Therefore, Mr. A can claim. Second paragraph I am not writing. You have to write the second paragraph, explain the case and relate it to the provision. Can claim rupees 1.5 lakh from Mr. S. I hope this is clear. I want a message from all of you. Everyone should be messaging. I have so many people attending the live session. Only 1 or 2 people are answering. Not done, guys. Not done. 20 people are watching. Good morning, Faisal. 20 people are watching. At least 20 messages for every question should pop up. 20 messages for every question should pop up. Good morning, Himanshu. Good morning, Shubhajit. Why have you guys joined late? Huh? Chalo, is it clear to everyone? You need to answer. Did you understand? Aryan, good morning. Good morning. Good morning, Faisal. How many times, huh, Faisal? Chalo, we'll go to the next question now after this. So after this, yes, please tell me. I did not understand, Jenna, what you are saying. What do you really mean by that? I did not understand. Okay. The next question that I want to discuss is again a September 22 question. Hello, net gaming. Oh my god. Got it? Okay. Yeah, you will. If you make reference to the cases, you will definitely score a little marks from that. Yes, Janam. No problem. So I want to solve this question now. I want to solve this question. Okay, this is a little long. Once you have read it, I'll scroll it up. Please read. I'll just make it full screen. And please drop the answer in the text. Mayank will give me the answer to this question. Mayank, you will give me the answer to this question. Once you have read the question, you have got the provision. Please write the provision in the live chat. Everyone got the answer? Oh, okay, Shubhajit Faisal. Continue with the maths class. Later come and try to solve it. No, Jainam. This has nothing to do with offer. This has nothing to do with offer. Read it again, guys. Read the question again. Okay. What about the others? What is your answer? Okay, Likita. Okay. Time is of essence. Okay. Whoever is that Nimma local Kannadiga, that okay, answer you have given me, but I want to know what provision. What provision? The point is provision. So please understand, ma'am, I got the answer, but I, couldn't figure out what should be the provision in this case. You got the answer because it was based on some common sense or some logic you used. So that logic is your provision. Okay. So Woolen Garments Limited entered into a contract with a group of women in July 2023 to supply various woolen clothes for men, women and kids like sweaters, monkey caps, mufflers, woolen coats, hand gloves, etc. Before the commencement of the winter season, the agreement expressly provides that the woolen clothes shall be supplied by the end of October 2023 before starting of winter season. However, due to prolonged strike, women group could tender the supplies in March 2024. When the winter season was almost over. First of all, so here you want them to supply you woolen clothes. Obviously, time is of essence. Correct? Yes. When time is of essence and you fail to perform within the time, the contract is what? Voidable. Please understand, even if you give wrong answers, the more you try to solve, the more you try to give answers, the more confident you will become in solving questions. So please, whenever we are discussing any question, try to give the answer, guys. So what we will write here is the second question for the day. So what we will write here is, obviously as per the provisions of Indian Contract Act 1872, when the parties intend to make the time of essence in a contract, then failure of one party to perform within time shall make the contract voidable at the option of the other party. Right? Will make the contract voidable at the option of the other party. So, the aggrieved party may either accept the contract or may reject. If the party accepts the contract, if the party, let's write rejects the contract first. If the party rejects the contract, he can also claim damages. On the other hand, if the party accepts the contract, what will happen? He can only claim damages if mentioned, right? So if I go to the question here, first, whether the company can reject, yes, therefore the company can reject the total supply of women group. Whether company can accept the total supply on request of the women group, yes. As the contract is voidable at the option of the aggrieved party, if the company wants to accept, they may accept the goods at the request of the women's group. Is it clear to everyone? Guys, got this? Can I move to the next question? Guys, did you get this? Should I move to the next question? Okay, this is very, very easy question. Where did I lose the question? This one. Chalo, tell me. This is again, as I told you, I chose all September 24 questions so that we can actually solve the questions that had appeared in the paper this time. And I want you to again read the question and write down the provision, and then we will discuss it. Okay? Giving you 2 minutes to read the question. Easy questions, so start dropping the answers. Provisions, please. Why no answers are dropping? Please drop your answer. Please drop your answers. What will be the answer? I will not give you the answer unless you give me. I will not give you the answers unless you give me. And please, if this session helps you, let me know. Drop a message to me so that I can, in that case, I'll conduct for the rest of the chapters also. Or I'll conduct it, maybe for other units or more sessions, because Indian Contract Act is huge. Everything is so huge. Or I'll conduct it for other chapters also. So just let me know if it helps you. What was that yes for, Sharon? Please give me the answers quickly, guys. Quickly give me the answers, guys. I was expecting, fast, quick answers. Mr. L let out his residential house to Mr. M for 50,000 for a period of 1 year. According to the rent agreement, electricity bill will be paid by Mr. L, but Mr. L could not pay the electricity dues up to 5 months due to financial hardships. The contract says L will pay the electricity bill, but he could not pay it up to 5 months because of financial hardships. Exactly, Likita. Khushbu, see, you are giving me the answer. You are giving yes or no, he can recover or not. But what I am asking you, I want the provision. As in, what provision will you write? That I want. Because see, getting the answer is very easy. The real problem that you will face there is actually trying to find out what provision you have to write. That will be your difficulty. So please understand, you have to tell me the provision that you will write here. Getting my point? So, but Mr. L could not pay the electricity dues up to 5 months due to financial hardship. The electricity board sent a notice of disconnection if not paid within a week's time. To avoid all this, if it is discontinued, who will suffer? Mr. M will suffer because he has rented the house. Mr. M paid the electricity bill of 50,000 with penalty. First of all, who was liable to pay? L was liable to pay. But who pays? M pays. Correct? Now, was there a contract between L and M that if I fail to pay, you pay? No. But he pays on his behalf. That means, can he recover it from L? Yes, he can recover it from L. Now, the question that comes here is that when I say he can recover it from L, the question is that when I say he can recover it from L, is it because there is a contract or the obligation is created without a contract? Without a contract. So, quasi-contract. Right? So, what is the provision we will write here? Question number 3. Yes, quasi. But you cannot write quasi-contract. You have to write which part of the quasi-contract, right? As per the provisions of Indian Contract Act 1872, an obligation may be created between the parties even without existence of any contract. Even without existence of any contract, right? Even without existence of any contract. When a person makes payment on behalf of another. But please understand, why am I making the payment? I'm just chumma making the payment, or I have some benefit that, some protection that I need, and so I'm making up because of some protection. When a person makes a payment on behalf of another to protect his interest, this is very important, he can recover the money paid from the person who was obligated to pay. This is point, payment made for a third person. If you remember, we had done the government taxes one example. The government taxes were due. That example we had done. So, whether Mr. M is entitled to be reimbursed by L. Therefore, Mr. M shall be reimbursed by Mr. L. Is it clear to everyone? Hello? Is it clear to everyone? Can I go forward? I have one more question. I have decided that whenever we do a live session, I will do 4 questions at least from that, from in that session. So, coming to the 4th question. Okay, this is quite an interesting question. So, this question was there in the September exam. Okay, I want you to read it. Huge it is. I'll scroll up once you are done reading this part. Even if I try it, it's better like this only. Chalo, I want you to read it. I hope you have read this part. I'll scroll up. Why delete answers? Huh? If it is right, wrong, why delete answer? Someone had written one answer. Okay. Okay, what else? Only one people will answer. Rest everyone will look at their answers. Stare at the others' answers, huh? Okay. Let's discuss this. Raghav found gold and diamond studded wristwatch value approximately 1 lakh on the roadside. He picked it up and then advertised in the newspaper that the true owner can take the watch after showing proper evidence. After waiting for a certain period of time, when the true owner did not turn up, he gifted that wristwatch to his son Mahesh. Can he do that? No. A few days later, Madhav, the true owner of the watch, somehow noticed his watch on the wrist of Mahesh. He approached him to collect the same, but Mahesh refused. In the evening, Raghav called Madhav and told him that he incurred 20,000 to find the true owner if he fails to reimburse him the lawful expenses incurred on finding out the true owner. He will sue him for recovery thereof or retain the possession of the watch with him until recovery. Even until recovery, even he can sell the watch for recovery of expenses. Advise whether the following actions of Raghav were lawful according to the provisions of the Indian Contract Act. So, can he will sue or retain. Can he retain the possession? Yes. But can he sue him? No. Even he can sell the watch. Can he sell? Yes, if certain conditions are fulfilled. Correct or not? Yes. So what all we will write here? As per the provisions of the Indian Contract Act 1872, when a person finds goods belonging to another, right, there is a quasi contract between the owner and finder, that the finder shall trace the owner and return the goods to him. The finder of the goods shall have a right to retain the goods for any expense incurred. However, he shall have no right to sue. Correct? He shall have no right to sue. The finder may also sell the goods if the lawful charges are 2/3 or more of the value of the goods. Correct? Therefore, can he give the wristwatch to his son? No. Warning Madhav to sue for the recovery? No. Retaining the possession of the wristwatch? Yes. Selling of the wristwatch? No. Why no? The value of the wristwatch is 1 lakh. Expenses is 20,000, which is not 2/3 or more of the value of the goods. Chalo guys, tell me, is it clear? Tell me, you want, I'm just trying out, experimenting this with you, all these sessions. If you feel instead of writing, I should just dictate the answer, we can do that. If you feel we just discuss the answers and do nothing, we can do that. If these writing sessions help you, or you want that you come online, you sit and write, and then I discuss what the answer should be, that you want, just let me know in the chat box so that I'll know how and in what ways we can do it so that it suits your needs. Okay? If you want more sessions, just let me know. I'll arrange more sessions. I'll just in that case I'll just I'll just make a few links for the live sessions in that case. Okay? So I hope this helped you, and with this I'll end the session here. Okay? And I'll see you in the next session. Keep studying, happy learning, and stay motivated, guys.